Your Honor, where we are in this case, I think we have cases 203136 and 24047 CF, Your Honor. Mr. Ferreira is the attorney on both those cases. Your Honor, we'd ask for a short pass. There's a report that's being provided to Mr. Williams. There may or may not, a conflict may or may not exist at this point in time that's being determined based on a report that was made to the jail. And so we would just ask to continue for 30 days just so we can get that report.
All right, state's response. Ms. McAfee?
Yeah. Oh, okay. Yeah. Apologies.
All right. February 22nd at 9 o'clock.
Thank you.
Yes, sir, Mr. McCoy.
I wish to proceed pro se, Mr. Clark. Okay. I'd rather not have Mr. Williams represent me at all, sir.
All right. If you will raise your right hand to be sworn in.
Testimony about this truth.
Do. I swear.
Right. State your name.
Devontae Jerome McCoy.
Mr. McCoy, you're asking to proceed pro se in case number 20 CF 3136 and 20 CF 4047. Is that correct?
Yes, sir.
And let's see. You have represented yourself in the past.
Yes, sir.
And how far did you get in school?
11th, sir.
You can read and write.
Yes, sir.
And you're not under the influence of any drugs or alcohol today, which would impair your ability to make this decision. Is that correct?
That's correct.
And you have not been diagnosed with a mental illness or suffering a mental illness that would impair your ability to make this decision. Is that correct?
Correct.
You understand attorneys are trained in the rules of evidence, criminal procedure, and the law, and they're to assist you in preparing for trial and preparing for pretrial motions and for other court hearings. And you understand that?
Yes, sir.
You understand you'll be held to the same standard?
Yes, sir.
You also have to do your own research and file your own motions and prepare for trial on your own.
Yes, sir.
I will leave, if I determine that you're competent, I will leave Mr. Williams as backup counsel, but he'll only be that when you ask for an attorney. You understand that?
Yes, sir.
And you understand at any point in time that you're asking for an attorney, that one can be appointed, that one will be appointed to represent you.
Yes, sir.
And in case number, unless there's been an amended information, in case number 20 CF 3136, you've been charged with one count of carjacking, which is a first-degree felony, punishable by life. Fleeing is attempting to elude high-speed reckless, which is a second-degree felony, punishable to 15 years in the Florida Department of Corrections and a $10,000 fine. And driving while license suspended revoked habitual, which is a third-degree felony. You understand that?
Yes, sir.
And let's see. And then you also have another fleeing and attempting to elude in case number 204047.
And when the last time that information has been amended, sir?
No, I said there has not been an amended information. That's what you were charged with.
Oh, yeah, it's been amended. All of them been dropped down to third degree, sir.
Oh, are they? I don't see 2047. Here's and then I see it. No, fleeing or attempting to elude is still a second degree. That's added. You got a grand theft, which is a third degree. Mm-hmm. Another fleeing and attempting to elude, which is a third degree. Mm-hmm. And no valid driver's license.
Right.
All right, so you understand that you could be facing up to 35 years in prison.
Right.
All right, you still wish to represent yourself?
Yes, sir.
All right. I am going to find that Mr. McCoy is competent to represent himself, and I'm going to leave Mr. Williams as backup counsel. And what do we need to do at this time, Mr. McCoy?
Well, about the conflict situation, if it shows a conflict, if I was to request counsel, it wouldn't be Mr. Williams, would it?
I mean,
like say if like he's
right.
said about the whole conflict.
I mean, that's another hearing altogether. You just asked to represent yourself. You're asking.
No, I'm still wanting to represent myself. I'm just about that situation because it's been a conflict, ongoing conflict since
he's your backup counsel right now, but that means it doesn't do anything. If you ever ask for an attorney and you don't want him, we'll have to and you have a conflict, we'll have to take that up at that time.
I've been put in for the conflict a while ago.
Sir?
I said the conflict been put in for over a month now.
I understand that, but you're not asking to file a conflict at this time. You're asking to represent.
No, I've already put in the conflict. The conflict has already been put in with the jail without having Mr. Williams. That's what he was just talking about, Mr. Clark.
There was just a complaint made to the jail admin, Your Honor.
Well, I put in multiple complaints with the court about Mr. Williams.
I don't know anything about that. I mean, if you're asking, what do you ask? If you're asking to have Mr. Williams removed and another attorney appointed, I might have to wait till Mr. Williams is present.
Oh no, we can deal with that when
you're asking to represent yourself.
I did.
I'm gonna find you competent to represent yourself. I'm just leaving Mr. Williams as backup counsel. If there's a reason that he can't represent you, we'll take that up if you ask for an attorney.
All right.
Okay?
Yes, sir.
All right. Now we're set for pretrial. These are old cases. Are we ready to set this for trial?
Set for trial. Well, see, the problem that I've been having is not having my defenses prepared for trial. That's the reason. That's the conflict I've been having with Mr. Williams. I've been asked for my discovery. I've been asked for all my depositions. I've been trying to prepare for trial, but he's not been not having my defenses prepared. Okay. I have none of my paperwork. He's not come. He don't come visit me. We don't have any type of communication.
Let me ask you this. You're representing yourself now. Tell me, we need to set another pretrial, then we need to set it for a trial. How much time do you need in order to set until we're ready to set this for a trial?
Well, if I can get all my discovery, I'll be ready for trial. If I can get all my depositions, my discovery, everything that I need.
Has there been depositions taken?
Yes, January 15, 2021. I believe it was on the 15th. I know it's January.
You have to file motions to have all those transcribed. They're not just transcribed.
I know that's the problem I've been having with Mr. Williams.
I know that, but you're going to have to do that yourself now.
Right.
Mr. Southern?
There have been depositions.
What I'm going to do is I'm going to give Mr. McCoy a month to try to get all those depositions, his paperwork, and then we'll set a trial after February 22nd at 9 o'clock, okay?
Sound good.
All right. Anything else today?
Yes, Ashley, yes. About my bond situation. Right now it's unreachable.
Okay, well, you need to file a motion to have a bond reduction. Your bonds have been reinstated.
Yeah, it was pulled and I can't afford it right now.
I understand. We'll have to have a bond hearing on that. Okay?
Therefore.
All right. That'll conclude the hearing. Good luck.
When is my next court date?
February 22nd at 9 o'clock.
Thank you, Judge. Like the last client's sister who was here, Mr. Vincent's mother is also here. She thought that he was going to be in person, so she is wanted me to let him know that she is here to support him on this file, Your Honor.
All right.
I have spoken. I'm sorry. Go ahead, Mr. Fleming.
Oh, that was Mr. Vincent.
Okay.
Mr. Vincent was just indicating that he did see his mother in the car.
Clear. Okay. Your Honor, I believe this is an adjourned competency situation, Your Honor. He was found incompetent at the last time that I was here. We had letters saying that he was restorable and that they were still attempting to restore him. I have not received any letter stating that he has been restored yet at this point. I don't know if the court has anything different, Your Honor.
I don't have anything additional in my file. I don't know if the prosecutor does, Mr. Fleming.
I don't. The last letter update I had was from December 14th, indicating that same.
I guess,
Your Honor, I requested an independent evaluation under Michigan Court Rule 5.733. If an innocent individual requests an independent evaluation, the court must appoint the person chosen by the individual, and I requested that through the public defender's office that has given me ineffective assistance of counsel. They're denying me my right to assistance of counsel and my Sixth Amendment right, and denying me the evaluation by the psychiatrist that's been waiting to do it since last April, since the competency was requested by the prosecutor. I'm not incompetent to stand trial. The community mental health staff inside the jail have said that I'm not incompetent to stand trial, and a person needs to be impaired to the state where they cannot assist their attorney in their defense. I've represented myself in court before, and have won cases against the prosecutor. And the public defender's office has stated prejudice to me, that they will not be assisting me. This attorney specifically, that he will not be assisting me in my defense, that I was guilty out of prejudice of both charges that I'm in here for. I called the public defender's office, they hang the phone up on me, they're adversarial. I need to request a pro bono attorney, a different attorney, until my family can assist me in hiring another attorney because they're giving me ineffective assistance of counsel. All I requested was an independent evaluation, so prejudice would not be made by the forensic center that has been made in the past or have been misdiagnosed. It's been declared that I was misdiagnosed in the past by the forensic center. And I would not, I would, under good cause, like it states in Michigan Court Rule 6125, MCR 6125, I have the right to request an independent evaluation. And it's already been stated in court that I requested it, and the public defender's office is refusing to grant me that right.
Well, you'll have to speak that over with your attorneys about the independent medical. And Mr. Feaster, you can have that conversation with him regarding any request in that line.
I had no way to speak to him. I called the office, the people hanging the phone up. One of the clerks at the public defender's office told me she's from West Willow, and that I can see her in the streets. I called and hang the phone up.
Mr. Vincent, there are phones at the jail for direct communication to the public defender's office.
And
yeah, the clerk that answered the phone at the public defender's office hang the phone up on me. That's what I'm talking about.
Mr. Vincent?
Yeah.
Hold on one moment. You were saying, Mr. Feaster.
For the record, Judge, I've spoken to Mr. Vincent numerous times from the jail about this matter. He's also spoken to Mr. Brown and reached out by letter to Chief Defender Simpson. So everyone is aware of his request, and we are working towards that, Your Honor.
All right.
I'm being given ineffective assistance of counsel. I have a right under the Michigan Court Rule to an independent evaluation. He's not stating that he denied my independent evaluation. He's avoiding saying that. That's
Mr. Vincent, Mr. Vincent,
yes, sir.
Attorney Feaster just indicated that you've spoken with 3 individuals in their office, that further they are working toward accomplishing your goal. So they have not listened to you. They are working toward it.
Right,
so what I'm going to do, I'm adjourning the competency hearing. I'm adjourning it to February 22nd, 2024, 9 a.m. as we have no report at this time.
All right, Your Honor, can I address one more thing to you, please? As far as you, I was out on personal recognizance bond before the University of Michigan arrest, and you can read in the police report that the reason they said they asserted the arrest against me was because they believe I was reaching for a weapon. That I did not have a weapon. That means they didn't have any reason.
Vincent, I would ask you not to talk about the facts of any of the cases pending against you. You are on the record.
It's been pending for a year. I have a right to a speedy trial and a speedy resolution under the Constitution. It's been a year. I've served time, and I served the time for this case, which is a year in jail, or without even being found guilty of the crime. That's against my rights. I'm a citizen of this country. I'm a taxpayer. I work every day, and I can't get effective assistance of counsel for a person to serve my rights. I requested an independent evaluation back in April. If I had that
Vincent,
I would not be in court right now.
Call this afternoon or tomorrow afternoon, and we can try to work through some of these issues.
Every time I call your office, somebody hangs the phone on me. They never connect me. What the judge is failing to realize is every time I call your office, my family's calling. My family's calling their office to speak to them about me calling there. You can ask my mother. My mother's had to call down there about the people hanging the phone and being disrespectful to me and personally adversarial to me every time I call. I'm not a threat to anybody. I got assaulted. I had a fractured rib, and then
Mr. Vincent, I've set it out. I need to get a report. I understand your concerns. Mr. Feaster understands your concerns. He indicated you can call the office. You'll be able to speak to him or another attorney at the office to address all of your issues.
Right. One question for you is
the defendant's bond will continue. Thank you.
Thank you, Judge.
Thank you, Judge. Have a good day.
That's a bail. I've been in jail for a year. I got
Court calls it
bail. That's a violation of my constitutional rights.
Court calls the case. People versus